granted to non-applicants for filing response or to file document.
DNA रिपोर्ट भी आ गया श्रीमान जी, परेशान हो रहे हैं, प्रताड़ित हो श्रीमान जी।
अभी तो कैंसिलेशन है, सुनेंगे आपको।
पिछली बार आर्गुमेंट हो चुका है श्रीमान जी, ये डिले करने का तरीका है। 6 महीने से मैं परेशान हूँ।
आपने पावर कब फाइल किया?
6 महीने पहले का ये 482 लगाया, इनको नोटिस मिला तब इनने वेल कैंसिलेशन का आवेदन लगा। अब डीएनए रिपोर्ट भी आ गई है, माननीय न्यायालय का ऑर्डर हुआ था, ऑर्डर होने के बाद
ये आपकी एप्लीकेशन है।
On merits also, magistrate says that magistrate money 5 में order 2024 PS Rati for Gurpal. Sir,
Pallav, today I have
409
on behalf of the objector.
405, 406, 407, 409, 417, 418 and मतलब 61 of the निष्पेक्षकों के अधिनियम एक्ट.
Yes.
Now मतलब learned magistrate मतलब rejects my application on 2 folds. On merits also, magistrate says that my averments made in my 156(3) is not sufficient to attract any of the offences. Well, on jurisdiction also, learned JMFC was of the opinion that just because I have invoked the provisions of special act, so therefore the learned JMFC would have no jurisdiction. On 2 grounds, the learned JMFC rejects my application. I preferred revision mainly on the ground that once learned JMFC is of the opinion that he does not have the jurisdiction, it ought to have not entered into the merits of the case. Finding favor with my submissions as regards jurisdiction, revisionary court says that the learned JMFC would have the jurisdiction for a simple reason, because 156(3) is at a very pre-cognizant stage and therefore there is no application of mine. So therefore, my lords, at the stage of 156(3), there is no question of, my lords, special court coming into picture. On the point of jurisdiction, I will not get into. Revisionary court holds in my favor. But on merits, my lords, revisionary court says that from perusal of my 156(3) averments, no case is made out. 3 grounds on which, my lords, my revision got dismissed as, my lords: A, that my application 156(3) does not have sufficient averments. I directly draw your lordship's attention towards para 13 of the revisionary court's order, my lord. From here, my lords, I'll try to establish my case. How, my lords, my case prima facie I am trying to make out.
Where is your complaint?
My lords, my complaint by way of an application I filed.
That is,
My lords, this is application IA 24956/2024.
yes,
Filed on 17/9.
yes,
My lords may have page 5 of this IA. This is my averments.
yes,
Right from para 11, my lords may kindly come down to para 11.
yes,
I'll read out for a lordship's, my lords, page 12 of this IA.
yes.
That it is specifically stated that respondent number 2 being the managing respondent number 3 to 6 were the directors of respondent number 1 company. Thus, all respondent number 1 to 6 are equally responsible for the criminal act of not paying back the amount to applicant. Despite asking from respondent number 2 to 6, applicant has not paid back the immaturity amount, which respondent number 2 to 6 are liable to make at the time of maturity. This act and conduct of respondent number 2 to 6 clearly attract the provisions of the IPC. That it has recently come to the knowledge of applicant that presently respondent number 7 to 9 are the directors of the respondent number 1 company, who also did not accede to the legal claim of applicant. Thus, they are also equally responsible for the criminal act. It is submitted that email dated 25/3/2023 was recently sent by applicant. By that time, respondent number 7 to 9 became directors of respondent number 1 company. Thus, they also become responsible for the criminal act. In the present case, that after the applicant started requesting for fund of his matured fixed deposited amounts, the directors gradually left the company after making sure to empty the company's finances and siphoning all of the company funds into their own other companies as non-EMI low interest loans, and from which they intend to not to recover any amounts and eventually bankrupt respondent number 1, thus finding a way to make the repayment of the hard-earned money that applicant has deposited with the respondent number 1 company. That the aforesaid conduct of respondent number 2 to 9 clearly attracts cheating, criminal breach of trust, and criminal misappropriation, and therefore they're liable to be punished. Plus 14, it is that the illegal act and conduct of respondents is punishable under section 403, 405, 406, 409, 417, 418, 420, 506, 120B, and 61 of the Nispekshakon ke Adhiniyam Act. That the aforesaid act and conduct of all respondents in not paying the amount to applicant despite its maturity amounts to dishonest misappropriation of property, fixed deposit of applicant for their personal gain. All respondents colluded to commit the offence punishable under 403 IPC, hence they all be punished for offence under 403 of the IPC. That respondent numbers 1 to 9 are entrusted with the property of applicant, that is his fixed deposits. And despite request of applicant, upon maturity of the respective fixed deposits, amount is not paid back to the applicant. Thus, the respondents are liable for criminal breach of trust for which they may be punished under 406 and 409 of the IPC. That the act and conduct of respondents have further attracted the provisions of cheating, which is punishable under section 417 of the IPC. In the instant case, cheating is done upon the applicant as his hard-earned money is not returned to him despite all the deposited amount.
Where is order?
Now, Malos may come down to the order, Malos. This is annexure P2. With my petition, the relevant page, it starts from page 17. Now, the relevant portion would be para 12. Malos may directly come down to page number, Malos, 24. Specific finding regarding that you did not make averments in your 156.3. Am I with Malos, para 30?
Para number
13.
30.
13. Page 24 of my petition.
Yes.
अतः आवेदन के समग्र अवलोकन से सर्वप्रथम यह दर्शित होता है कि आवेदन पत्र में भारतीय दंड संहिता की धारा 403, 405, 406, 409, 417, 18, 20, 506 व 120 बी के अपराध घटित होने बाबत आवश्यक तथ्य उल्लेखित नहीं किए गए हैं। आवेदक के द्वारा अनावेदक क्रमांक 1 कंपनी में विभिन्न फिक्स डिपॉजिट किया जाना आवेदन पत्र के साथ प्रस्तुत फिक्स डिपॉजिट की रसीदें से अवश्य दर्शित होता है, किंतु उक्त फिक्स डिपॉजिट की राशि का भुगतान दुर्भावना से बेईमानी पूर्वक या आर्थिक लाभ के आशय से नहीं किया गया है। यह आवेदन पत्र से प्रथम दृष्टया दर्शित नहीं होता। So the learned revisionary court is of the opinion that my averments which I made in my 156.3 is not sufficient to attract any of the offences. That's the very first ground of the reason for my dismissal of my revision. Second ground of dismissal is, my lords, may kindly come down to para number 18, my lords, of the impugned order. Sorry, para, my lords, para 12. Para 12, the para preceding this 13.
Yes.
The reason is, my lords, that my lords may kindly come to para 12. भारतीय दंड संहिता की धारा 403 संपत्ति के, my lords, बेईमानी से दुर्विनियोग, भारतीय दंड संहिता की धारा 406 आपराधिक न्यायस्थान.
How these offences will be made out?
No, this is made out for a simple reason that my all my fixed deposits had been deposited with the respondent number 1 company.
Yes.
My lords, the entire hardened money had been with them. Despite maturity, my lords, they did not return back. Now, what found favor with the revisionary court?
निक्षेपों का अधिनियम देखिए 6 में. Reference में. Yes.
So basically,
so there will not be 420, 406, 409.
Lords, all I have in my detailed application, I have demonstrated how. My lords, may kindly come down to my application again, because this is what, my lords, my specific case is. If this averments are considered to be gospel truth, because definitely, my lords, 156.3 interference would be warranted. My lords, may kindly come down to the application
Even
again.
if it is taken as a gospel of truth, then also.
My lords, may kindly come down to the special act also, cheating also.
Yes.
Because they were entrusted with the property, and my lords, despite this, my lords, they did not return back my amount. The specific averments are from, my lords, para 14 of my application.
So you have some case under 6.1. इसमें बताइए.
6.1 also, my lords, may kindly see. My lords, may firstly see 6.1.
Yes.
Where any financial establishment defaults any repayment of deposit on maturity, along with any benefit in the form of interest, bonus, profit, or any other form, as promised, or fails render service as assured against the deposit, every person, including the promoter, partner, director, managing manager, or any other person or an employee responsible for the management or conducting of the business or affairs of such financial establishment, shall on conviction be punished with imprisonment for a term which may extend to 6 years. Now, my lords, here the relevant portion would be, my lords, financial establishment.
So whether there was any permission from superintendent of police.
My lords, this is for 6.1. This is a criminal offence, my lords.
Yes.
For that, my lords, just because police did not take into account my complaint, I had to approach 156.3. And therefore, my lords, this is a stage prior to registration of FIR. Once court order,
Yes,
all these compliances would be done.
6.1 only.
My lord, 13 facts are required to be.
My lords, because before my respected senior start, there are 2 more grounds on which my revision got dismissed.
Yes.
Because those are required to be addressed. My lords, may kindly appreciate allegation against the petitioner herein were taken into consideration by the learned revisionary court, which could not have been taken in the light of Kailash Vijayvargiya, recent law laid down by Kailash Vijayvargiya and also Lalita Kumari. Now, that particular aspect of the matter, in fact, the entire order of revisionary court is vitiated the moment, my lords, they take into account the allegation against me. Because whether it's a case of counterblast or not, my lords, can't be considered at this stage. I'm only on the point, my lords, my averments made in my 156.3, my lords.
Yes.
And how these are attracted if your lordships are not convinced, may I take just your lordships again to that application, my lords. Because how specific provisions I have mentioned in my 156.3. My lords, one more thing, my lords, with utmost amount of respect.
ये 420 वगैरह तो कुछ नहीं है. They, you have made investment, they have not returned. It is a only offence may be under 6(1).
Chunki my lords are already has given a view for 6(1). 420 maybe for a moment may I try to convince you.
So there is no inducement, nothing. You invested your money,
but for not giving amount despite
it was for financial gains to you.
Ultimately, that is to be looked into. This is what I submit.
Company is not a fraud. Company they exist kar rahi hai na. They invested your money also. So if they suffer financial loss, then offence will not be made out.
For that particular investigation must be done. I humbly submit, Manoj, this is why I refer to Kailash Vijayvargiya directly on the point that allegations can't be gone into. At this stage, Honorable Court would only see Manoj 156.3.
Yes.
How both the courts have dealt with my application. That is one of the subject matter of challenge. Revisionary courts has taken into account something which they ought not to have taken into account. Allegations against me, averring my averments are not proper, that they are not proper. I just pointed out to the lordships. This is on merits I have to submit before the lordships.
Yes. Yes, respond.
My lord, my friend has not informed this court that he himself was the director of the company, and it is he who deposited the amount and issued the receipt. The entire receipt of an acknowledgement has been issued by him, he himself, and therefore the provision which he is saying is attracted is not applicable. Second, my lord, the matter is already pending before the NCLT. This he has, my lord, may have a look of para 24. He has already approached the NCLT for the recovery of the amount. So these are nothing but the arm twisting method where his money and we have specifically stated that he has committed embezzlement of crores of rupees. Now he could not get the amount because of the pendency of the inquiry. Everything is pending against him. These are the arm twisting method which he is adopting, and it is a settled proposition of law that the principle of vicarious liability would not be applicable in a criminal case. My lord, he has read the complaint. May I have a look of the complaint again? There is admittedly no allegation against any managing director or director. Merely saying that all the directors, does he want himself to be implemented as an accused? Because he too was a director. My lord, may I have a look of para 24? Yes. Of the complaint. That though a civil litigation between the applicant and respondent number 1 is already pending adjudication before the NCLT, Indore bench at Ahmedabad, but the same pertains only to the recovery of amount of applicant with interest. But in the present case, applicant has elaborately disclosed role of each respondent in cheating him. Where is although these are where he has explained the role of the directors, he has not stated anything which director has issued the receipt, which director is not refunding the amount. So it's a merely just to put the pressure so that the criminal proceeding may not be drawn against him for making the fraud from the company himself. And so far as the question 6(1) is concerned, we are NBFC, so 6(1) is not applicable.
You're a banking company.
Yes.
Then it will not.
So you are a banking company.
I am an NBFC. Admit me. It's not a dispute.
No, you are NBFC or
NBFC, not banking financial.
so NBFC may do not be attracted.
Yes.
It's a financial establishment का definition sir.
Yes. Individual association of individual firm or a company incorporated so and so receiving deposits under the scheme. Corporation, cooperative society.
The deposits were not made under any scheme.
They would fall.
It has to be under some scheme.
No, उसके बाद, but will not.
You will be NBFC is also financial
But
institution.
not include. But does not include.
कहाँ लिखा है?
सर उसी मैं पढ़ देता हूँ.
State government or central government or banking company.
Any scheme or arrangement or in any other manner, but does not include a corporation. A cooperative society owned or controlled by the state.
So you are corporation.
No, sir. Or a banking company is defined under the so and so.
So you are not banking company. You are NBFC. It's non-banking. NBFC is non-banking. Yes.
Permit and miscellaneous fund is too poor.
Yes.
My lord, this act would further not be applicable for the simple reason, my lord, that this act was created, my lord, and the purpose of this act is to create, my lord, to save the money invested by public. Now, my lord, admittedly, applicant herein, he is not a public. Now, there are specific rules, my lord. He was a director. My lord, the receipts have been annexed by the applicant himself, which shows that being the director, he has issued those receipts. He has invested his money. Now, my lord, I have uploaded, my lord, the rules, my lord, by which the companies accept deposits. If my lord would just have a perusal on the reference column.
Yes.
But the deposit, it will not fall under.
Deposit and acceptance rule.
Sir,
Yes.
companies के सर इसमें rule 2(8) है सर कि deposit क्या होगा?
Yes.
If my lord would just have perusal, my lord, deposits includes any receipt of money by way of deposit. If my lord may get.
Yes.
By way of deposit or loan or in any other form by a company, but does not include. But 8 is important.
Yes.
Any amount received from a person who at the time of the receipt of the amount was a director of the company or a relative of the director of the private company. Admittedly, my lord, when he made those deposits, my lord, he was the director of the company. And the second petition is by his son. I do not fall, the deposits made by him do not fall under the category of deposits which are accepted by the company. And my lord, if my lord would just have a perusal, my lord, although the learned quote below have added, but my written arguments, if my lord would just perusal, my lord, I have quoted section 45 QA of the NCL RBI Act.
ये तो including है ना?
It does not include.
कहाँ पे पढ़ रहे हैं हम? Does not include. 8th में the amount received from a person.
सर उसका सबसे सर अगर 2 का हेडिंग पढ़े सर डिपॉजिट का
2.
हाँ सेक्शन 2C.
Yes.
Deposits includes any receipt of money by way of deposit or loan or in any other form by a company, but it does not include.
Yes.
And my lord, section 45 for a moment.
Yes.
Because my lord, although it was mentioned in their application under 156(3), but not argued. And my lord, my written arguments, I have quoted section 45 QA of the RBI Act. The only remedy which lies to him is 45 QA of the RBI Act, which he has already availed. My lord, that my written arguments, if my lord would just have perusal.
Yes.
But internal page 6, my lord.
When you have filed?
My lord, I have annexed it with this as well, my lord. But prior to this complaint, my lord, that is on 29/9/23, he has already filed.
You are referring to annexure?
My lord, that is page 19, my lord. With my written arguments, it is 9/12/24.
ये तो है नहीं. There is nothing
Sir,
like.
reference में है.
अच्छा, reference.
Sorry.
Yes. Yes, written arguments.
Sir,
9/12/24.
Sir, page number 19.
Yes.
This was the notice received by us, my lord, by the NCLT.
Yes.
Now, this is under section 45 QA.
Yes.
Now, if my lord would just have a perusal of 45 QA, so that I have quoted at page 9.
Yes.
Sorry. Page 6. Page 6.
6.
हाँ, दे देंगे साहब को दे देंगे.
Yes. 45Q.
Sir.
Yes.
But even assuming there was some deposit made by him, 45 QA speaks power of company law board to offer repayment of deposit. Every deposit accepted by an NBFC company, unless renewed, shall be repaid in accordance with the terms and conditions of such deposit. So, my lord, the only remedy is 45 QA, which he has already availed, admittedly.
Out कुछ कहना है?
My humble submission, whatever my respected senior has argued, because that can't be considered, my lords, at this stage. For a moment, my lords may have, my lords, section 401 of the CRPC.
Yes.
Or the old CRPC. My lords, admittedly, HDFC Security is directly ruling on the point that at the stage of 156(3), accused has no right at all. My lords, at the stage of revision, definitely, my lords, 401 subclause 2 comes into picture, where they must be given an opportunity of hearing. Now, for a moment, my lord, may kindly see, my lord, section 401 subclause 2 of the old CRPC, my lords.
Yes.
Now, to what extent they can argue before this honorable court, that would be a legal question before the lordships. They can't, none of these material which they have relied upon can be even taken into consideration. For a moment, my lord may see 401. I point out a direct judgment on the point.
Yes.
My lords, 401, subclause 2 reads like this, my lords.
Yes.
No, it says like this: High Court's powers of revision.
Yes.
By virtue of 399 subclause 2, the same provisions would also be applicable to the Sessions Court. Subclause 2 says no order under this section shall be made to the prejudice of the accused or other person unless he had been an opportunity of being heard, either personally or by a pleader in his own defense. I like to emphasize upon the expression in his own defense. At max, my lords, he can defend the orders of the revisionary court and the JMFC. He can't place any new record, my lords, before lordships, which is not the mandate of 156.3, my lords. My lords may for a moment may have this direct judgment on the
Facts cannot be considered, but law can be. If he is citing some sections, it
with
can
utmost
always
amount of
be-
respect, my lords, in his own defense, my lords, has been interpreted in this judgment.
Yes.
That would amount to, my lords, questioning the veracity of the allegations in my 156.3. Because if they, my lords could consider their allegations in their submissions and their written arguments, that would amount to, my lords, question my submissions which I made in my 156.3. That is not the mandate of law. Lalita Kumari, Kailash Vijay Vagarge would directly come before the lordships, my lord. And to my rescue, my lords. My lords may kindly come down to this judgment, my lords. 47.6 is a direct, my lords, point interpreting this 401 subclause 2.
In 482, I can see. Though session court may not see.
My lords, even 482, I humbly submit.
Yes.
Because revisionary court also, ultimately, honorable court would be, is exercising 482.
No, I have to see whether there is any abuse of process of law
My lords,
or not.
at max, I don't know, my lords, what is the view of your lordships. What
Yes.
I can gather is, say for example, honorable court is dismissing, my lords, nothing remains in the with me, my lords. In case honorable court is even inclined to do anything, at max, this honorable court would only remit the matter back to the JMFC. Honorable court would not, my lords, order for registration of FIR. I humbly submit. So if we talk about the equity, my lords, I would be nowhere, my lords. But my lords, they have all the opportunity, all these submissions can be considered at the time of investigation. We are, my lords, at the stage of, my lords, very nascent stage. Even FIR has not been registered yet. All these materials, my lords, they have all the opportunity. Say for example, my lords, if FIR gets registered, HDFC Security says, my lords, they have no prejudice. Say for example, FIR gets registered at the stage of 157, police would have, my lords, the ball would be in the court of police. Police would see, my lords, whether, my lords, this is a fresh fit case for launching an investigation or not. So at the stage of preliminary inquiry, also, my lords, at the stage of 157, my lords, my FIR can be, my lords, can be shelved at that point of time itself. Further, my lords, even if police is of the opinion that this is a fit case for launching an investigation, my lords, it is not mandatory for police to file a final report. They can file closure also. But at this stage, my lords, so deep scrutiny of my 156.3 with utmost amount of respect, my lords, would be, my lords, I would be nowhere, my lords. Now, for a moment, my lords may see 47.6 in this paragraph. In his own defense has been interpreted.
Yes.
Page 541. The expression in his own defense comprehends inter alia for the purpose of 401 subclause 2 in defense of the order which is under challenge in revision before the session judge or the high court. So my humble submission is, at max, my lords, they can defend the order of JMFC and that of the revisionary court. But my lords, there is nothing, my lords, they can't place any new material. Even this honorable court, with utmost amount of respect, I say can't consider those my lords, records. My lords, my humble submission would be before lordships. My lords, they have ample opportunity. I am at a very nascent stage. For this, my lords, for a moment, my lords may kindly see HDFC Security also. My lords, this is also says that even if, my lords, FIR gets registered, my lords, there would be no prejudice caused to them. 27 paragraph may kindly be seen. In fact, they are not required to be heard at that stage. It appears to us, para 27, it appears to us that the appellants approached High Court even before the stage of issuance of process. In particular, the appellants challenged the order dated 4/1/2011 passed by the learned magistrate under section 156(3) CRPC. The learned counsel appearing on behalf of the appellants, after summarizing their arguments in the matter, have emphasized also in the context of fundamental rights of the appellants under the constitution that the order impugned has caused grave iniquities to the appellants In the circumstances, it was submitted that the order is illegal and is an abuse of process of law. However, it appears to us that this order under section 156(3) CRPC requiring investigation by the police can't be said to have caused any injury of irreparable nature, which at this stage requires the quashing of the investigation. We must keep in our mind that the stage of cognizance could arise only after the investigation report is filed before the magistrate. Therefore, in our opinion, at this stage, High Court has correctly assessed the facts and law in this situation and held that the finding of the petitions under 227 of the Constitution or under 482 at this stage are nothing but premature. Now, my lords, at this stage, my lords, I like to refer to Lalita Kumari. A very important, my lords, paragraph 111. My lords, may kindly see. My lords, this is on the point of equity. My lords, may kindly see 111, my lords. Besides the code gives the power to the police to close a matter both before and after investigation. A police officer can foreclose an FIR before investigation under section 157 of the code if it appears to him that there is no sufficient ground to investigate the matter. The section itself states that the police officer can start investigation when he has reason to suspect commission of an offence. Therefore, the requirements of launching an investigation under section 157 of the code seeking closure of the matter. Therefore, police is not liable to launch an investigation. So, Manoj, at this stage, my humble submission would be, we are at a very nascent stage. Whatever, Manoj, by my respected senior is saying, correct or not, that is subject matter of investigation. Investigation would be launched, Manoj, only if FIR is registered. At the stage of 157 also, Manoj, police can not proceed, Manoj, as per if they feel, Manoj, because ball would be in the court of the police. And this honorable court at max, even say, for example, I'm not saying anything, but say, for example, honorable court is convinced. At max, Manoj, it would be remitting the matter back. Kailash Vijayvargiya is directly on the point.
That's all.
That's all, Manoj.
Yes, just add 2 lines. My friend has argued that everything has been dated. So while going through the documents, may have a look of the complaint which he has filed. He has nowhere specifically stated as to what role has been played by the individual. Second, he admits that the matter is pending before the National Company Law Tribunal. So once he has already approached the tribunal, he cannot be permitted to adopt arm testing method, and we cannot be compelled to go for investigation for nothing. Unless you prima facie established that you have a case, and he says that this court cannot look into the documents. We had never approached the revisional court. He approached the revisional court, notices were issued to us. Here also it is, he has approached, notices have been issued to us. And then we have appeared. So my submission is, my lord, at the threshold, the complaint has rightly been dismissed.
Heard, reserved for order.
Manoj, this is Kailash Vijayvargiya, Manoj, would be relevant, Manoj.
Yes,
In
give
this,
the
as
copy.
regards veracity of the
Judgment
allegation.
which he has uploaded.
Yes,
With the arguments.
yes.
Obliging.
Number 55.